Okay, good afternoon, everyone. This is Angelo DeCaro, the president of the Central Texas TMA group. I would like to welcome Second Wind today to our presentation and turn this over to Michael Parker, who will give you a more detailed introduction of Second Wind and what they're going to talk about. Michael, it's all yours.
Good afternoon, everyone. Welcome on behalf of the Central Texas chapter of TMA. We're privileged to have Second Wind consultants with us today. In particular, we have Aaron Todron, who is the president of Second Wind, and Bob Donazzi, who is business development director for Second Wind. Aaron will tell you, and I'm looking at his kind of brief bio here, that what Second Wind does and has done very well is they've learned to use Article 9 as a business preservation tool, whereas it typically is thought of as a kind of a liquidation tool. And so that is what Aaron and Bob will be talking about today. A little quick history about both Aaron and Bob. Aaron is an active attorney, practiced in Boston for about 6 years before he started Second Wind, and has been doing that now for the last 11 years, and has done over 1,600 Article 9, we'll call them reorganizations, during that period of time. Bob has a really interesting background. Mr. Donazzi has spent 18 years in Hollywood as a feature film producer, executive, overseeing creative development and structured film finance before he came back to the East Coast and started with Second Wind. And with that, I will turn it over to Bob.
Thank you, everybody. Thank you for coming. First of all, thank you, Michael, Angelo, Jenny, and a nod to Bob Butler for helping put this together. Business preservation is a passion. It is what led Aaron to found the company. Aaron was a practicing bankruptcy attorney who essentially was looking for a better way to fill the gap left by the judicial process. Chapter 11 filings have an abysmal success rate for smaller businesses that don't have the size or the fortitude to make it to a successful discharge. So he thought there must be a better way. And the process we're going to talk about today is not proprietary to Second Wind in any way. We feel it's a tool that if the community of advisors, investors, lenders understood better, could be used not only to the benefit of preserving businesses, jobs, and economic activity, but at the same time would create opportunities for them to transact, which are otherwise being lost when those businesses are liquidated rather than being preserved. So I'm just going to give everyone a high-level overview of UCC Article 9 asset sales, how we deploy them, what they've been traditionally used for, and talk about just some of the technical requirements and what opportunities they present for all of us here, and then turn it over to Aaron, who will go on to highlight the Article 9 reorganizational process with some real-world examples. And we're going to let this conversation today be led organically by interaction rather than using a slide deck. So I thought I'd start with a little story. Earlier this year, just as Corona had been underway for a few months, in the financial press, you saw articles about the impending tidal wave of bankruptcies that were expected. You saw articles about the expectation that we would lose 30 million American small businesses. You saw articles about lenders doing triage on their portfolios and so forth. And you saw a lot of articles about how much stimulus would it take to preserve American businesses and could we afford it? So I wrote a post on LinkedIn for just my community of TMA folks and lenders, and it had the audacious title of, "Can UCC Article 9 save the US economy?" And what I meant by that was that if in fact we could preserve businesses rather than liquidating them, might that not have more impact on economic recovery than any amount of stimulus and debt we could ever print? So that was the idea. The reason I mention this is this post was read by the editor of economics and business for Bloomberg Business Week. His name's Peter Coy. He promptly called Aaron and myself, and he said, "I need to write about this." And we said, "That's fantastic." What I thought was most interesting about the first conversation with him, though, is when he said, "I consider myself to be a student of distress, and I've never heard of this before." And likewise, at the TMA Cleveland event in the fall before the pandemic, Article 9 sales were on people's minds. You'd hear conversations in the hallway, people asking questions about it, and there was a panel, and I think it was called ABCs versus UCC Article 9, something to that effect. And on the panel, the gentleman speaking about Article 9 was asked a question, and he was asked, have you ever heard of a UCC Article 9 sale being conducted in the context of a going concern business, of a business that was still operational? And his answer was, no, I've never heard of that. And as you can imagine, I was thinking to myself, this is unacceptable. I mean, we've seen this done. We've done it ourselves, well over 1,500 times. So what I'm not going to say, what we aren't going to say today is that UCC Article 9 represents a panacea, but there are many, many situations in which it is a fit and would be a better fit than the options being pursued today. So just a couple notes about the Uniform Commercial Code. I'm sure everybody here is aware that it consists of a standardized set of laws that regulate business transactions, financial contracts. It's been uniformly adopted in all 50 states. The Article 9 asset sale. What Article 9 is. Article 9 was written for the benefit and protection of senior secured creditors to allow for a post-default asset sale that avoids the judicial process. And the logic behind it is simply that in default, the fair market value of assets is considered to be, rightfully so, the liquidation value of those assets. And so far as there is going to be almost always a deficiency balance remaining between what's owed to the senior position and the liquidation value of those assets, then it's unreasonable to think anyone else should be considered to have a security interest in them or should be able to impede the sale of those assets. So Article 9, in short, was a way to expedite the ability of a senior creditor to transact on their asset base post-default. That's the liquidation use of UCC Article 9 sales. But we're here to talk about business preservation. In a business preservation context, if you take the thinking a step further, a UCC Article 9 sale as currently used, the one thing I left out is in the asset sale itself, all subordinate liens and liabilities are removed from the assets. In a business preservation context, if you bring to the table defaulting borrower consent, the senior creditor can sell the assets of the business while they are still operational, meaning while the business is still going. And in so doing, what happens is that the asset sale itself becomes a transfer of the business operation, still running, and the full value of the assets in use is transferred through the asset sale into a new legal purchasing entity under new ownership. You've now preserved the going concern operational value of that business via this kind of asset sale. So why has this not been done before? Well, it does require defaulting borrower consent. And this is the piece that has traditionally been missing. The only way to incentivize a defaulting borrower into essentially giving up ownership of their business is by prepackaging a solution such that they can extract value from the new business entity that's inheriting the assets. So if you can carve out for them a means to earn and participate in that new business entity that's inherited the operation, they now have a path to resolving their issues and their liabilities on defaulted loans made to Oldco without a bankruptcy. So that's just a high-level flyover view. But essentially what we're talking about is preserving a business, removing the value of a business operation with a streamlined single creditor asset short sale. And in doing so, ultimately, not only is that good for business preservation and for the economy and for jobs, but it creates opportunity for my side of the company, the folks that I tend to work with, lenders to lend into situations they would not have been able to lend into, for business intermediaries to transact on businesses they would not have been able to transact on, and for investors to invest directly into situations they would not have been able to. So that's a high-level overview. I'll stop there, see if there are any questions as we turn it over to Aaron.
Thanks, Bob. And also thank you, Michael and Angelo and the TMA community for having us for a minute. So yeah, I'm going to piggyback on what Bob said. Let's talk about a real life story. I'm going to use a plastics printing company in my example, but this story can apply to any company in any industry, whether it's asset heavy in manufacturing, for example, or extremely asset light, say a service-based industry. We have proven this model out regardless of the type and also regardless of the size. Obviously, when we first started doing this, we did it for smaller businesses, and it works extremely well for companies running revenues between 1 and 10 million in revenue. But it also works equally well for lower mid-market companies upwards of, between 60 and 90 million. So in this example, we're going to talk about a plastics printing press. We'll call it Company X. Company X was chugging along on a slow growth path over the period of 10 years. They made the decision to invest in some new age technology and some very expensive machinery to expedite their process, make it more efficient, and also to bolster the quantity that they can produce. Well, after they made the investment, everything is going well, and unfortunately, the market turned. Pick your reason. Whether new technology after that came in, competition moved in across the street, COVID-19 happened, whatever it might be, their revenue declined. And once it declined, thereafter it plateaued, and the level at which it plateaued rendered their debt service unsupportable. So far, this is a story that I imagine many of you are familiar with, be it COVID-19 or in your decades of experience beforehand. Businesses of all shapes and sizes come to experience financial distress, and they have very few options available. So right now, this business has a senior secured loan in the amount of, say, a round number, $1 million. They have vendor debt below that. They have some equipment financing below that. Perhaps to try to get them out of their struggle, they took out the dreaded merchant cash advance. And here they are in a situation, their revenue has plateaued. That plateau is insufficient to cover their debt service. They have no path out. They are in a downward cash flow spiral. So what options do we have here? Well, the first option, generally speaking, that's available is a Chapter 11 bankruptcy. We know Chapter 7 is available, but again, we're talking about business preservation. There is a viable business here in Company X. It does have a product. It does have revenue. It does have equipment, assets, employees, and enterprise value. So let's forget Chapter 7 and talk about Chapter 11 for just a moment. Chapter 11 is the only legal tool available to distressed business owners to try to restructure their contracts, which is the backbone of a capitalistic society, to allow them to reemerge from those unsupportable positions. Well, the statistics show that 75% of the businesses that file for Chapter 11 protections fail to make it through the plan. Of the 25% that actually succeed, the majority of those are quote unquote big business. Those are companies that have disposable income so that they can afford the bankruptcy process. That's the conundrum. Most of the companies that fit this description in the country don't have the cash that is required to make it through the bankruptcy system. There's a new subchapter 5, which I'm sure many of you are aware of, that constrains the time. And from the subchapter 5 trustees that I've spoken with has not created the relief that the authors of that provision hoped for. Also, once you're in subchapter 5, an objection is an objection is an objection. It still must be dealt with. There are still adversary proceedings that stem from that, and it still can create an extremely time-consuming and expensive process. And again, companies are there. They don't have the run room. They don't have the cash. They don't have the time to survive, even within a subchapter 5. So again, this is not to say that all bankruptcy is bad, but it's not certainly a tool that can be used across the board for distressed companies. What other options do we have? Well, the company could borrow more money. That's going to be a challenge because they're already in a financial situation. a financially challenged situation. They might qualify for merchant cash advances. I'm sure many of you have experienced the challenges that come with that. And typically when a company is exploring options to buy their way out of their challenges, that simply expedites the path to failure. You have a few other options, an assignment for the benefit of creditors. That is also challenging, seeking to get permission from the entire debt schedule for a cram down also takes time, also takes money, requires oftentimes a receiver, requires an assignee, and it lacks finality. Bob and I have been talking to many people specifically in the TMA communities over the years, and I've met very, very few that have actually completed ABCs. There are some ABC friendly states out there where they specialize them and they get good at them. But it's not a very efficient tool and not widely used for a number of good reasons. So what else is left? All we've talked about are pretty unpleasant, ineffective options. The only thing that's left is liquidation. And that's what we're seeing a lot of. Banks simply acknowledging that the business has no path forward. They don't want to take their chance in a bankruptcy proceeding. Perhaps it's not even an option because the business doesn't have the capital to make it through or to pay for a lawyer in the first instance. So they shut the business down. So here we come to Article 9, Article 9 of the Uniform Commercial Code. As Bob said, a right afforded to secured creditors to convey their collateral outside of the judicial system, acknowledging the fact that, quite frankly, liquidation in the judicial system is expensive, time consuming, and takes resources. It's not an efficient process. So instead, they wrote this code, the Uniform Commercial Code, this provision in the code that allows secured creditors with the consent of the borrower to convey their assets that were pledged as collateral, stripping the liens off and the encumbrances off, so as they can realize the value of the collateral that was pledged to them. Great. Still, we're not doing anything to preserve the business. So if you take Article 9 a few steps further and you arrange the entire transaction, then you have the ability to preserve that value. So what do I mean? There are 4 parties to any Article 9 sale. There's the distressed business, there's the secured lender, there's a buyer, and there's the financier that funds the buyer. Sometimes the financier can also be the buyer, but for purposes of this example, let's assume that they're 2 separate parties. So normally, an Article 9 sale stops at those first 2 parties. There's the borrower, the defaulting borrower, and there's the secured lender. The secured lender communicates with the borrower and says, look, you're done. Why don't we cooperate together, convey these assets at public auction through Article 9, avoid the legal mess. This will give us the best opportunity to maximize the value on these assets, minimize your personally guaranteed deficiency balance, and we can move on. That is the main way that Article 9 sales are used. However, if you enroll, identify, collaborate with, and facilitate the transaction with those second 2 parties, then you have the capabilities of conveying the business at that same forced liquidated valuation, but without shutting the business down. Nowhere in the Uniform Commercial Code is it required to close a business in order to conduct an Article 9 sale. Also, written directly in the code provides lenders the ability to conduct a private Article 9 sale, which means that we as trusted advisors, as transaction facilitators, as intermediaries, as turnaround specialists, have the ability to capitalize on the relationships that we have to play our part in this transaction. So in this company, we have a plastics printing company. They have their assets. They have $1 million note. The forced liquidated value of the assets is, say, $200,000. We identify a buyer. We identify the financing that's going to come up with the $200,000 to incentivize the bank to go through the Article 9 process. The buyer is a strategic buyer so that through the transaction, the business can remain alive, up and running. To the outside world, it never has to shut down for 1 minute. The financier benefits from this situation by providing the financing. As Bob said, this can be a business development model for businesses that would otherwise be shut down and liquidated. Article 9 can turn those unsaleable opportunities into transactable businesses. So in that situation, the secured party, the secured lender wins, so to speak, it reaps the benefits from the situation because the assets are being conveyed as an operational enterprise. We can get a premium on the dollars higher than what they would otherwise get in a liquidation scenario. Additionally, this process removes the burden from them to have to go through that liquidation process themselves, removes the burden of legal costs, of the time that goes with it, and the uncertainty that comes with not knowing if anybody is actually going to bid at a public auction at the end of the day. So to remove that entire burden, give them a sum certain, and that sum certain in a shorter period of time that is a higher amount than what they would otherwise get, creates a huge value for secured lenders who have non-performing credits in their portfolio right now. On the back end of the transaction, on the buyer side, on the financing side, be it factors, ABLs, anything of that nature, there's a huge amount of creativity and opportunity there by turning bad deals into good opportunities. Rather than walking away from a business, walk them through an Article 9 sale. The result is a clean, brand new, unencumbered business enterprise that you can leverage its assets and confidently in first position. The original business, the value proposition is quite obvious, but it goes from on death's door to continuing its operation. Sure, the business owner must give up ownership, but that doesn't mean they can't play an operational role. They can be a non-owner CEO in the new entity. Or perhaps their desire is simply to exit. We can pave the path for them for an exit as well, where they would otherwise not have any because their business was unsaleable and the value of their debts surpassed the enterprise value of the business that they would hope to sell the business for. So, that's generally the scope of the transaction. It's an Article 9 sale, which is ostensibly a controlled, private short sale of business assets of a distressed business that can be conducted through Article 9 to preserve the business operation for the benefit of the secured lenders, for the benefit of the investors, the private equity groups, and for the benefit of the financiers who are seeking to turn bad deals into financeable situations. This tool can be used proactively or reactively. Reactively to help facilitate the defaulted non-performers already in your or your clients' portfolios, and can be used proactively for business development, again, to turn those deals, those bad deals, into good opportunities. And that's the way Article 9 works. That's the way Article 9 can be used for business preservation, which again is far more than just the sheer liquidation component that it was initially designed for.
Aaron, thank you. I neglected to say at the beginning, but I put in the chat, if anyone's got questions, please stick them in the chat or feel free to try and otherwise get them forward. Aaron, can you give some examples of, say, your most complicated Article 9 sale or your smallest Article 9 sale, or, some of those?
Yeah. Article 9 sales get complicated in a number of different ways. Obviously, the more complex the business structure is, the more moving parts there are. So if you have a company with multiple subsidiaries, then you have to ascertain who the creditors are, what the creditor security is, if there's cross collateralization involved, so as to make sure that you are conducting the Article 9 sale through the right party. Another issue that makes Article 9 sales more challenging are licensing and credentialing issues. Take, for example, trucking and logistics. There are a number of interstate licensure and credentialing components that must be transferred from the old company to the new company, the seller to the buyer. And sometimes that can add some complications, no question, be it pharmaceuticals that require the same type of issue. Oftentimes, the asset base itself can make the transaction a little bit more complicated. Assets aren't always perfectly identified and accounted for in a warehouse. Sometimes they're spread all over the country on the road. Again, if it's some sort of transportation or logistics company. Oftentimes, the cash flow of the business makes it very challenging. Like anything, this transaction does not happen overnight, and we have to implement certain cash flow protection measures so as to ensure the business's viability throughout the process. Oftentimes, the most obvious example comes from the merchant cash advance world, where they send those 406 notices to account debtors and they freeze cash for these distressed businesses, and that kind of halts the entire operation. That's frustrating because the merchant cash advance is trying to claim dollars that have already been pledged as collateral to factors or senior lenders, or have already been purchased in some way, shape, or form, but they don't care. They freeze it all the same. So it's hard for me to say what the single most complicated Article 9 sale is. Those are the types of factors that contribute to the complicated nature of it. But what I will say is that there's a way around everything. For credentialing and logistics, we're yet to identify something that cannot be transferred in some process or another. When it comes to assets and the debt schedule, it might look like a true crime scene connecting all the dots, but there is always the answer, and you can always identify by reviewing the documents, who the transaction must go through. More often than not, these things are pretty clear, pretty quick.
Aaron, we're getting some questions in the chat about second lien liabilities and how you deal with those, or perhaps maybe you don't have one blanket, the secured lender doesn't have a blanket lien. Maybe there are a couple of different lenders that have liens over different portions of the assets. How do you deal with things like that?
Yeah. So the most often time we see that example, Michael, is when you see a senior secured lender, but then you also see lenders that have purchase money liens on big pieces of equipment. So if you have a $1 million debt to a bank, you might also have purchased $1 million piece of equipment that was financed by the seller, and they're going to have they're going to have that super priority on that one asset. In that situation, we go through the entire debt schedule, or one goes through the entire debt schedule to ascertain, what is a necessary operating expense and what is a simple debt, and what is paper that can be relieved in the Article 9 transaction itself. So if you're talking about a machine, there's no one singular answer. If this is a machine that is not pivotal to the operation itself, then perhaps the best decision is to surrender that equipment back to the seller financier. If it is in fact integral to the operations, then again, that is something that can be assigned to the purchaser as a necessary operational expense. And we can either assign that, continue the payments, or create a new agreement altogether. So it really depends on the basis of the debt, Michael, what it is encumbering, if it is necessary or not. And you go down a stoplight analysis to determine what does the business need, what does the business definitely not need, and then fill in the gray areas in between to ascertain what's what through the Article 9 sale.
Okay. Another question, can you kind of compare the costs associated with this Article 9 process for an average company to a 363 bankruptcy sale process. So not a complete organization in Chapter 11, but someone who's jumped in and just sold that under the 363 of the bankruptcy code.
Yeah, absolutely. And I see a question that I would like about residual liabilities as well, which I'm going to hop into next. But the cost really depends. On the smaller scale, so I guess in this situation, we're talking about second wind consultants. This, to be completely candid with you all, this was not intended to be about second wind consultants, but about Article 9 itself. So the cost varies. How we price our engagements is with a flat fee, and we term it out over a period of time based on the economics of the underlying business. Obviously, we're talking about a financially distressed company, so that's why we term it out over a period of time to make it affordable. But you know, that's a separate matter, and I'm happy to talk about that offline. But just to get to the Article 9 mechanics itself, Michael, I'd love to respond to the question about residual liabilities post Article 9 sale. So this comes up a lot, and it's a really important question, the big successor liability question. And you know, my answer to you is that it is not a risk. So 1,600 transactions later, we have had 0 successor liability claims succeed. So there are a few reasons for that. One, because this is not a sale between buyer and seller. This, again, is a sale afforded to senior secured lenders. It is conducted by the bank. It is a liquidation tool. So because the bank is the one selling the assets, that disrupts the chain of continuity between the seller and the buyer, so as to make it very challenging for any sort of successor liability claim to exist. Also, Article 9 bakes into it some very clear, very binary requirements. One is procedural, 2 are just black and white check boxes. The 2 black and white check boxes are that the buyer must be a bona fide arm's length third-party purchaser. That means that it can't be anybody with similar ownership as the original business, and it can't be somebody with of the direct family of the original business owner. So if you satisfy the bona fide third-party purchaser box, then you must determine whether or not adequate consideration was exchanged. Because we're doing private sales, adequate consideration is necessary to determine. In a public sale, all you have to make sure is that it's done commercially reasonable, and whoever the highest bidder is, you know, that is what determines market value. So in order to overcome that, we always get professional third-party appraisals so as to check that box so that it cannot be questioned. Third, regarding successor liability, baked into the process, there's notice given to every single secured party or party of interest so that they are aware of the transaction prior to its closing. They have 14 days to object, and one of 2 things will happen. They either won't object or they will. But either way that goes, we're going to know prior to closing whether we have objections or not, which means that we don't close unless we are completely comfortable with the situation. If we don't receive any objections, then guess what? We can close the transaction as planned, and if any objections come up after the fact, they have lost standing to provide that objection. If we do have objections received, we have to make sure that they are valid objections, and then we deal with them. And in order to be valid objections, they can't claim, oh, I had a buyer that would have paid more. That's not a valid objection. Their objection must be based on the merits of this individual transaction, which is either this is not a bona fide third-party purchase or adequate consideration was not exchanged. And both of these things are going to be heavily documented and corroborated with full transparency. So that's why it's never going to happen. The final reason is that in order to claim successor liability, you need standing. And remember that this is a transaction done through the first position. In our example, it was $1 million note and the forced liquidated value of the assets was 200K. So let's say we do the Article 9 sale for 250. Well, that's a $750,000 deficiency balance. Even if they said, you know what, your appraisal was wrong and fraudulent, I could have got twice as much. The assets are worth 500K, or 3 times as much. The assets are worth 750K. There's still a shortfall for the first position creditor, and nobody else is, they're still not going to get anything. So for all of these reasons combined, I'm not going to say it's impossible that a successor liability claim can't arise, but that's why we have a 0 for 1600 plus record.
How about subchapter 5 proceeding? I'm going to redirect you here just a little bit. I know you said you talked to some subchapter 5 trustees and they told you that it hadn't worked out quite like they wanted it to, but subchapter 5 allows a debtor to retain control, right? Allows a debtor to retain control. And you specifically indicated that in the Article 9 process, they can't, right? If I'm advising a debtor in those two aspects, certainly I'm going to want to talk to them about subchapter 5's ability to retain control. Article 9, what's going to be your reply, or you know, what's the counterweight for Article 9 to that?
Yeah, great question. So when you walk through an Article 9 transaction, you have to give up ownership of your company. That's the truth. Furthermore, you're left with a personally guaranteed deficiency balance. More likely than not, most of the time we see that happen. Most of these business debts are in fact personally guaranteed. So one, by virtue of our ability to preserve the business operation through Article 9, we also preserve the ability for the business owner to earn from the company, again, in a non-owner role. So that creates a financial incentive for the original business owner to go through this process, albeit while giving up ownership. Now, 2 things happen after that. One is you must, you know, again, this is a little bit about the second wind process, not so much Article 9, but we walk everybody through what's called an Article 9, an offer and compromise program, which is to settle those personal guarantees at affordable levels based on what a liquidation analysis would provide. So we conduct the offer and compromise analysis based on liquidation. What would a creditor get from that personal guarantee? We all know that filing a suit and getting a judgment against a personal guarantor only has any value if there's any assets behind that. And if that person were to file an individual 7, that paper would be ripped up and there'd be nothing left. So that's particularly bad when lenders have to spend money to get that judgment, to execute on that judgment, to perfect it, only to find out that they're not going to get anything at the end of the day. So by cooperating with those lenders, doing the liquidation analysis, walking through the OIC or offer and compromise process, and moving on with personal guarantee settlements, we can also assure debt reduction and also the ability to pay for those OIC settlements by virtue of the guarantor's ability to earn from the company. So the personal guarantee deficiency balances, it plays a huge role in this. Also, once those personal guarantees are resolved, we also preserve the path for that business owner to re-earn or repurchase an equity stake or an ownership interest or the whole thing back. If we don't preserve the business, they can't buy it back or earn it back in the future. If we do, they can. So when you compare that to a subchapter 5, well, the risk is high. You need money. If you can't demonstrate plan viability, which no cram down is guaranteed, meaning expect to pay off the entire balance, you're getting no debt relief whatsoever. And you risk a Chapter 7 conversion, which again is going to leave you with no debt, but also no income and also no business. So when faced with that situation, when the statistics are vastly against me, and I don't have a viable plan, and I don't have the cash to make it through, and I don't have control over what my creditors are going to say or do or object to, and I'm not receiving any debt relief whatsoever, then to me, a subchapter 5 filing is exceptionally dangerous. So is there a circumstance where it works out well? Absolutely. I'm not here to hate on bankruptcy. I'm just here to make sure that everybody knows all of the options available so that when they see certain fact patterns, they understand which is the best path forward.
Okay, I got another one in the chat. How do you deal with employee issues or benefit plans and such?
So the whole Article 9 process succeeds by leveraging reality. What would happen in reality if we do not complete the Article 9 process? And the answer to that question depends on the circumstances involved. So more often than not, we are able to, preserve the business, preserve the jobs, and preserve the economic value. That's why we do this. But it is a real sale. It is a full-blown bona fide purchaser. Real adequate consideration is exchanged. So to the extent that there are employee benefits in the old company, there is no way to guarantee or predict, as I sit here right now, whether or not a similar type of plan can be started in the new company. I will tell you that there is a model where we can create ESOPs, employee stock option plans, to be the buyer, and we have done a number of situations where the employees were the buyers of the company, and that was that is a very successful model for us in the right situation. But Michael, that falls in the category of business decisions, whether to continue employee benefit options. And what we create is a blank slate for the new company to make better business decisions than what got them in the financial distress in the first place. So it's certainly possible. The door is open for it. That's not for us to make. That's for the employees and the business owner to decide on a case-by-case basis.
Okay, I've got a couple more questions here. I'm not sure I fully understand it, but the question is, what about bulk transfer or other notices? I'll wait for some clarification on that. Let me move to the other question. And that is, who do you work for in the process? I mean, where do your loyalties lie in the process? Are you hired by the debtor? Are you hired by the lender? Where do you come into the process?
Yeah, good question. We always are engaged directly by the distressed business, which is interesting because we don't get a lot of repeat business. So what we have done is we have created, relationships with trusted advisors, lenders, ABLs, factors, intermediaries, private equity groups, venture capital groups, M&A specialists, all people that are engaged in the distressed business world. And, everybody from all different sides of the transaction. I mentioned the 4 parties before. There's a benefit for everybody. And for that reason, and for the fact that when we go through this process, we provide full transparency and corroboration of every step of the way. So everybody's satisfied with what we're doing because they understand that it represents the best path out. Ultimately, everything comes down to the single fundamental that business failure is worse for everybody. Business preservation is better for everybody. But regardless of where, what the source is of the business, it's best to engage directly with the distressed business so as to avoid any conflict of interest. That is whom you're representing. That is the business that you're preserved. Therefore, that is the necessary party for engagement.
Have any of your Article 9 sales ever subsequently filed for bankruptcy, to your
Yes.
knowledge?
Absolutely.
Are those
The article-
typically reorganization proceedings or just liquidation proceedings?
Well, look, what Article 9 is designed to do is preserve the business operation and give it a fresh start in a way that in certain situations can be far more effective than the alternatives. What it does not do is fix the underlying problems that got you there in the first place. And yes, there will be a new buyer, a new ownership structure, but that does not necessarily mean that that owner is going to be able to identify the problems and fix them. The management consulting space is heavily saturated in this country in all industries, in all shapes and all sizes. That is not what the Article 9 is meant to do. So that certainly is, so it represents a powerful tool in the back pocket of management consultants. And again, that is also an alliance that we as a company have created. But for subsequent bankruptcy filings, look, that's just the reality of the case. Not all the buyers have fixed the mistakes, and despite the reorganization, they still made some decisions to get themselves into more financial trouble down the line, and the business turned out to be not viable, or trends changed, technology arose, COVID-19 happened. Again, pick your reason. Businesses definitely have filed. It's just the nature of capitalism.
Okay with you if I just open it up for questions for anybody else?
Yeah, absolutely. And just for the record, I'm happy to make myself available, as is Bob, after the 2 o'clock time, or directly. We will be happy to give you our direct contact information, so that if anybody has any questions or concerns or comments, I'll wrap with you guys all day.
So I see, Paul Osa, you've asked this question a couple of times, and I'm not sure how to phrase it. If you want to jump on and try and ask that question of Aaron or Bob, I'd appreciate it.
Also, Steve, Bella, I don't know what you mean about bulk transfer or other notices. If you could clarify, I don't know what you're referencing.
Steve,
Well, there you go.
go ahead.
We
Steve.
can hear you, Paul.
Okay. So my question is, I had a case, okay, on which we could not even, we had to really watch Article 9, because in oil and gas, if you could have a secondary lien holder who you are not paying right now, okay, that can go and trump directly to the well and file a lien on the well and bypass the lender. How are you guys preparing for that? That's something that the banks are really worried about, it, because the secondary lien exposure, and upon filing an Article 9, those guys can file a lien right away.
So secondary lenders, subordinate lenders, cannot trump a senior lender as long as that senior lender properly perfected their UCC 1 financing statement, which is presumably their blanket lien.
No. Let me correct you. I'm talking about an unsecured lender who is delivering goods to the well. Okay, I am the oil field services guy. Then, since you're not paying, the debtor is not paying that unsecured creditor. Okay, the unsecured creditor can go exercise a secondary lien position, go directly file a lien at the well. Okay, same thing happens in the construction, and then now the ultimate customer is not paying the bank. The ultimate customer goes direct and says, I don't care. I'm paying. I need my lien removed. I'm paying this guy now. And therefore, he bypasses the priority lien holder position of the secure lender.
Right. So you're saying that they get some sort of trade, a trade lien in that particular situation?
Trade lien or a statutory lien, I think is what he's saying.
Right. Well, yeah, that, trade liens come up frequently, also in construction. What I would say is we put together a global picture. If this whole thing hits the fan, it's a bit of a state by state analysis as to how high the super priority lien goes when you have a unsecured creditor filing a trade lien. So for example, if everything is honky-dory and the first position is getting paid with no action, no legal action, no recourse, no default, and a trade lien pops up, yeah, businesses aren't allowed to just stiff their trade creditors. That's why the law affords them the ability to file those trade liens and to get that priority status. However, what my experience has been is that if we have a global default, then a court is not going to issue a super priority lien if we announce to everybody that that this business is on the brink of liquidation and all of the creditors are pursuing collection. Furthermore, part of the process is doing asset protection. So if we don't, we know that when there's blood in the water, all of the creditors try to get their piece first, because if it goes to the judicial arena, whoever's first is going to get all of it. So everybody tries to swipe at what available cash there is as soon as possible, so as to ensure that they get something. So if there's no viable business, then there's nothing to preserve. We protect the business and its cash flow, make sure all accounts are properly insulated, so that they can't be swiped from this sort of sudden or non-judicial lien swiping procedure through a judgment lien or a vendor lien or something like as you described. But without diving a little bit deeper into the facts of that particular case, I can't really get to any more detailed than that.
Yeah, I can jump in real quick, Aaron, to save you maybe. Paul, I think what you're talking about with respect to the oil and gas case that you referenced, that is unsettled law right now, and it's a lien priority fight. In fact, I have that lien priority fight up at the Fifth Circuit right now. We're waiting for them to rule on that. And that's a problem whether you're in bankruptcy or in Article 9 or anywhere else. It's just a lien priority fight between the oil and gas producers and the senior secured lender. And I saw Steve Beulah jump on for a minute there and then jump back off to maybe ask his question. Steve Bella, if you're there, Steve.
I'm here. Let's see, hang on. Can you hear me on this?
Yep.
I can now.
Okay, my question was, my last Article 9 foreclosure sale was in California. And in state law, if you're going to have all or substantially all the assets transfer, we had to do a bulk transfer notification to all the trade creditors. And we started out the process thinking we only had to notify the senior lender, who obviously we were already working with. But it turned out that we had to notify not only the trade creditors, but an employee who had filed a lawsuit. So what are there different notification requirements leading up to, and what's the notice period? And does it vary by state? I mean, who all needs to get noticed?
The general rule is that perfected secured lenders of interest or parties of interest. So we run a UCC debt schedule. We identify who has perfected their liens with a UCC 1 financing statement filed with the Secretary of State, which is public notice. And those are the people that we file. If there are other people that we know of, unsecureds or any other parties of interest, we tend to over notice. The goal is to give everybody notice. That's really what you want to do. And if they have objections, you want to deal with them right up front. We're not afraid of that because we know that they're going to be without merit, and we're going to be able to reject them. So more often than not, our rule of thumb is run the UCC 1 debt schedule, notice everybody on there, and then thereafter ascertain if there are any other parties that should or could raise some noise and notice them as well.
So clearly, if they have, by this time, they probably have pretty large trade creditor balances that are past due. As a general rule, do you notice them or not?
General rule, yes, we do.
Okay.
There's no surprise that the company is feeling financial distress. So yeah, in that situation, chances are more likely than not that we are going to notice them.
Right.
Again,
And
law
that's-
only requires those who have perfected their interests to receive notice. So we certainly cover our behinds that way. But just as a matter of prudence and responsibility, we do try to notice everybody.
Is that like a 30-day notice, 60-day notice, or
Technically,
10-day
it's
notice?
10. It's a 10-day notice with 2 days on each side for mailing. So it's a 14-day notice.
Got it. All right, that's clear. Thank you.
Okay, we just got a minute left. Rob Colorina had a question. If you can jump on, Rob, and ask your question.
Yes, thanks, Michael. Aaron, can you hear me okay?
Yes, sir.
Okay, great. Just a quick question. In these processes, have you picked up any observations of new investors, coming in from either, different regions or a mix of either PE or corporate or family office investors? Any observations there?
No. We've seen trends for investors trying to acquire portfolios of paper, default business loans of all shapes and sizes. But in terms of trends of specific private equity groups seeking to enter certain industries or make certain investments, we really have not seen any sort of trend like that.
Okay, thanks.
All right, I think we are at time. I want to thank very much Aaron and Bob for their presentation today. And Jenny put in the chat their contact information if you have further questions or want to get a hold of them to talk about an Article 9 sale. I'd appreciate it. But thank you, everyone, for coming. We're TMA of Central Texas.
I'd like
Jenny,
to
did you have
reinforce,
anything final? Or Ange?
I'd like to reinforce what Michael just said. To both of Robert and Aaron, thank you very, very much for your time today. It was very enlightening. And Michael, thank you also very, very much for coordinating this and managing the session today very well. I hope everyone enjoyed it.
Thank you.
All right. Thanks, everyone.
Thank you, everybody.